SJC-08047, Commonwealth v. Inez Kolenovic.
May it please the Court, Thomas Townsend for the Commonwealth. This is the Commonwealth's appeal from the trial judge's allowance of the defendant's motion for new trial on the grounds of ineffective assistance of counsel. The judge concluded that defense counsel's tactical decision to pursue an alcohol intoxication defense rather than a combination alcohol intoxication plus post-traumatic stress disorder defense was manifestly unreasonable. We submit that that was an error of law. In this case, there was an abundance of...
An error of law or an abuse of discretion?
It was an error of law because that was a legal determination whether counsel's tactical decision was manifestly unreasonable. I submit that as a legal determination that's open for this Court to review.
Well, you're basically saying an abuse of discretion is an error of law. Is that right?
An abuse of discretion would be an error of law. Under Rule 30, motion for new trial review, the standard is whether there was an abuse of discretion or other error of law. I submit that this is an error of law, whether counsel's tactical...
It's an other error of law?
Right, other error of law. Not
You're saying that as a matter of law, it was not manifestly unreasonable, and it's not a discretionary judgment.
That is our contention. It is a matter of law. Defense counsel is charged with having discretion on the best defense to pursue. In this case, there was abundance of evidence from various witnesses. I believe 8 witnesses at trial testified to the defendant's alcohol consumption or his intoxication. He had, at the time of his breathalyzer test, which was 4 hours after the homicide, he registered .16 and .17. Through expert testimony, that was extrapolated to .26 to .30 at the time of the homicide.
So you're saying that a dual diagnosis, which would have the PTSD component contributing to his alcohol dependency, wouldn't have made any difference to the jury?
Correct. I don't believe it would make any difference.
Because they knew how just over-the-top drunk he was, and so there was no way that this would have altered any assessment of his responsibility?
I believe just as in the Smith case, which I submit is the closest analogous case to this.
That's the one with Tourette's.
That was a combination of Tourette's and alcohol abuse.
Agree to an insanity defense in Smith, which makes it quite different from this case.
Right, but if we look at the second prong of fairing, whether it was an otherwise available substantial ground of defense, I believe that because alcohol intoxication was a key component to both defenses, obviously alcohol intoxication, but also it was the triggering effect, according to defense experts. It was the trigger that manifested the PTSD. So alcohol was a necessary component to both defenses. So I believe it's not wholly dissimilar to what was actually presented to the jury.
But it would be in the form of not guilty by reason of mental illness, not a lack of criminal responsibility. It wouldn't be an inability to form the requisite intent. Right?
Well, according to the trial judge in her decision, it could have been either. It could have knocked it down from first-degree murder to second-degree murder.
But it would be. I'm just saying the defense would be presenting a lack of criminal responsibility.
It would be an insanity defense, which would have a cool instruction. That would be a not guilty by reason of insanity. What defense counsel was gunning for here was a manslaughter conviction.
But she says if there had been a dual defense, he could have had both.
Well, he could have had both, but this is a classic archetypal...
Yeah, I'm sorry, dual diagnosis.
Right. This is a classic judgment call that's reserved for defense counsel in consultation with his client, whether it would be preferable to go with one defense rather than a combination of defenses.
Well, if it deprives him of a defense, are we still there?
No, there's a long line of cases where defenses are not necessarily irreconcilable. Defense could be complementary, as in Smith, as in Glover, as in Walker.
As in here. As here. These are not non-complementary defenses.
Correct. But still, it is up to defense counsel in his professional judgment, of which discretion should be bestowed. He felt that it would detract from the very solid evidence of alcohol intoxication. The defendant had never.
Focus on that statement right there. In the case you cite and rely on, the Heichman case, has some significant language might be applicable here, that a decision by counsel not to present mitigating evidence, that's a different circumstance, of course, but you rely on it by analogy, can't be excused as a strategic decision unless it's supported by reasonable investigations. And here, this attorney did not make an investigation because he wasn't really convinced that there was any, didn't really know, except from looking at TV and reading generally, what PTSD was.
Well,
He couldn't tell it from looking at his client. So how can you have that discussion you're talking about if his client doesn't know about it and he doesn't know about it?
Well, I submit there was adequate investigation. His retained expert, Dr. Fox, conducted a full psychiatric examination. He arrived at a diagnosis, primary diagnosis of PTSD, and also a diagnosis of alcohol abuse. He met with counsel and co-counsel for 45 minutes to discuss his findings. Counsel did not want to pursue that. He suggested not that he have testing to determine whether he had PTSD. He had already diagnosed him with PTSD. He wanted psychometric, independent, objective testing to support his diagnosis if this were to be taken to trial. So this is not a case as in Roberio, where there's some allegation that there was a mental health defense out there and defense counsel never pursued it, never got an expert to look into it. He had a diagnosis from Dr. Fox, who was prepared to testify. In fact, he felt so strong about the diagnosis that although counsel told him not to submit a report, he submitted a 2-page report 2 weeks before trial stating that his diagnosis was a dual diagnosis of PTSD and alcohol intoxication. So counsel did have that. It wasn't a failure to investigate. He made a strategic decision with that in front of him. And actually, the trial judge alludes to that. This is on page 17 of the addendum. Firmly of the opinion that PTSD in combination with alcohol consumption affected the defendant's state of mind at the time of the incident, Dr. Fox recommended a second opinion in further testing, which included objective testing he was not qualified to administer, to confirm his diagnosis. So counsel had a diagnosis of PTSD. This is not the Roberio type of situation.
Let me ask you this. Given that, you have defense expert who is feeling quite adamant about this diagnosis, and is there at some point, and I appreciate it's very different from Roberio, no question, but is there at some point where it isn't reasonable of the defense attorney, when he's got this information and somebody who's saying this is really the cause, to just say, well, as for strategically, I don't think it's good, and I don't think it's going to get me anywhere. I mean, is there some point where you cross a line where it's just not adequate defense?
I think the question presented here is who makes the call? Is it defense counsel in consultation with his client, or is it the retained expert? Defense counsel felt very strongly about alcohol intoxication, as strongly as Dr. Fox felt about the dual diagnosis. Dr. Fox was prepared to give, and indeed did give, a diagnosis of alcohol intoxication standing independent and alone. Counsel here had reasons to focus on alcohol intoxication, not just the evidence, but the defendant had never been diagnosed with PTSD. In fact, he had never had any mental health history. Now, that counsel could believe that the jury would look with skepticism on the all of a sudden newly discovered defense of PTSD. He wanted to focus on the staggering amounts of alcohol that this defendant imbibed in the 12 hours before the murder.
But that's
go through it in
exactly
footnote 5.
where the judge, and taking your point about Roberio, went beyond just what the doctor had said, and said what he failed to do was really talk to the family about it when they would have discovered, maybe not evidence of going to a doctor, because that's not the kind of thing they talked about, but of headbanging and other violent, extremely violent outbursts, and the incidents that supported the serious incidents over the history of this individual's life that would have supported potentially a PTSD dual diagnosis with alcoholism. That's where the focus was, not just alone on that, but what you're talking about now.
My point is, counsel had enough information before him to make the decision within reasonableness. I mean, it was not manifestly unreasonable to make the decision to go forward with alcohol intoxication defense. It was not wholly successful. It was successful to some extent. The jury didn't convict on the deliberate premeditation. But it wasn't, just because it wasn't wholly successful doesn't mean we can go back with 20/20 hindsight and say he should have gone with Plan B, which wasn't a whole lot different from Plan A.
But didn't he say he didn't realize at the time, this is Attorney Bongiorni, in his affidavit submitted in connection with the defendant's motion for a new trial, that he did not realize that the defendant was also suffering from intermittent explosive disorder and subtle traumatic brain injury due to multiple head traumas, and that if he had received reports such as what he got, from what was presented from Drs. Leaf, Pittman, and Gervitz, he would likely have presented this evidence at trial in an effort to show that the defendant did not kill with extreme atrocity or cruelty, deliberate premeditation, or malice aforethought, and that he lacked criminal responsibility at the time of the killing. So it's not like the defense attorney is saying precisely what you're saying. He's basically saying he screwed up.
Well, that's Monday morning quarterbacking, I submit.
Well, I understand, but...
If it had been acquittal across the board, then he would have had a different view, I suppose. And if he had gone forward with a dual diagnosis, he got convicted of both counts, both theories of first-degree murder, he could look back and say, well, maybe I shouldn't have gone with the dual diagnosis defense. I think that's tainted by hindsight. During his testimony, he was quite strong in saying, putting forth his view that alcohol defense was more favorable than a dual diagnosis defense. He was afraid that was going to be viewed as an excuse by the jury. And this is a very experienced, highly competent criminal defense attorney making that determination. An added bonus of having strictly an alcohol intoxication defense is that the Commonwealth's retained expert, who is eager to evaluate this defendant, never got a chance to do so. Repeatedly, the Commonwealth moved to have him evaluated. When they got wind of the two-page letter that Dr. Fox submitted to Attorney Bongiorni, the Commonwealth immediately moved for an evaluation by its retained expert, Dr. Martin Kelly. Attorney Bongiorni told the judge, we have no intent of doing a criminal irresponsibility defense, and Dr. Fox's opinion will not rely on the defendant's statements. So they were able to keep our retained expert at bay. So the only expert that the jury heard from was Dr. Fox, and he opined that the defendant was not criminally responsible for the homicide.
Can I ask you about the instructions? Was there evidence that the defendant knew that alcohol would trigger extremely violent behavior? I mean, would trigger his mental illness if he knew that he had a mental illness, et cetera?
Well, not on the trial record, because that was not submitted at trial, but in the reports, there is evidence, and I cite to it in my brief, that he did know because he had several episodes where he blacked out and there were violent results.
But the defense says it was all self-harm, not harm of others.
If you look at DiPadova, it doesn't talk about assaultive conduct. It talks about violent conduct. And there was one time where he had to be restrained by 6 police officers. There was one time where he destroyed caused some destruction of a furniture store. There were times after his blackouts where his friends had to recount to him what happened. So our argument is, even if the first prong of fairness is satisfied, the second prong is not satisfied because this was not a substantial defense, because the Commonwealth would have gotten a DiPadova instruction saying if he knew or should have known that alcohol triggered his latent mental disease, even if he didn't know about it.
Even if he didn't know he had a latent mental disease?
That's what DiPadova states, that's what Berry states, that's what Brennan states, what I think would be the controlling precedent at the time. Even if he did not know of the, I know DiPadova and Berry say that, even if he did not know about it, if he knew that the alcohol triggered
blackouts?
Triggered violent conduct. It doesn't have to be assaultive according to the language in DiPadova. It has to be violent outbursts.
Even just violent
conduct.
against himself or against property?
Well, according to the language in the model instruction, the appendix in DiPadova, it would be violent conduct. But again, that's dealing with the second prong of Safarian, the substantial prong of the second
But
prong of
wasn't
Safarian.
there also evidence that that he was psychologically unsophisticated and he had little or no awareness of his of any mental condition?
There was evidence he was not a good historian. After the fact, there was evidence that he had slow functioning, not necessarily, I mean, this isn't unusual for criminal defendants for that, but I do want to, one point I do want to make is that this is unlike a lot of cases where Attorney Bongiorni, once he had the recommendations from Dr. Fox, he discussed it with his client. And his client agreed, and agreed is the word that Attorney Bongiorni used in his testimony, agreed not to pursue the overlapping defense, but to go with an alcohol intoxication defense.
But how important is it? Is this case to be decided on whether or not those defenses were incompatible or inconsistent?
No, even if they're complementary or not necessarily irreconcilable.
If they're complementary, why not do both?
Well, because for the reasons I stated, the Commonwealth would have an expert testifying at trial. They would add an abuse excuse component to the trial rather than a straightforward.
But if he was really aiming at, if ultimately his reasonable goal was to get it down to a second or to an involuntary and not really get an acquittal, why would he have been hurt by pursuing the alternative defense?
He thought it would be watered down. He thought he had such a strong, if you look at the evidence, this is a very strong alcohol intoxication defense. To have tagging along with it is the language he used, or riding a second horse, would detract from it. And I think he should be accorded discretion in his professional judgment to make that determination. And again, I point this court to the Smith case where there was also a mental health component with alcohol, and this court said it was fine to go with the alcohol defense, even though it was not. Even though it was compatible with a dual diagnosis defense.
Is there any detrimental evidence that might have come in had there been a dual diagnosis defense?
Well, presumably the Commonwealth's expert would have said that he did not suffer from that. And so then we would have, rather than the focus being taken from the alcohol intoxication, the focus would be put on whether or not he actually had PTSD, which is something that defense counsel wanted to avoid. I see my time is out. Thank you very much.
May it please the court, my name is Michael Schneider and I represent the defendant appellee Inez Kolenovic. I would suggest that in many ways, first of all, I would suggest that the judge took a lot of care in this, coming to her decision, that she spent a lot of time. She gave the Commonwealth every opportunity to put on its own witness on the second prong, the prejudice prong of Safarian. And I would suggest that that her decision was amply supported by the evidence, that there is no error of law, and that...
Let me ask you this question.
Sure.
Let's assume the attorney was skeptical about pursuing this. Remember, this trial took place a long time ago. PTSD wasn't quite so well accepted back then. Maybe would have been viewed as a sort of a bit of a fake. Alcohol defense clearly there in spades. But he says, okay, we'll hire Dr. Johnson to do these psychometric tests, and Dr. Johnson does them and concludes, I don't see PTSD there. So counsel decides not to use that. Your client is convicted. 15 years later, he gets a bunch of doctors to retest him, and they say, oh my gosh, this is just awful. Motion for a new trial.
Well, that would have been a very different case, because in that case, defense counsel would have actually conducted an investigation, would have spoken to done the psychiatric follow-up that Dr. Fox was explicitly recommending. And I would suggest this case is far more, the error by counsel is far more egregious than it was in Roberio.
But at the end of the day, of course, Dr. Johnson did do an assessment of all of the tests that would have been given. He did. Well, and said he doesn't have PTSD.
So Dr. Johnson, for the purposes of his rebuttal testimony during the third day of evidentiary hearings in this case, did review a small stack, a couple of inch stack of documents that was handed to him by the government.
The testing.
By the testing. He focused specifically on one test, the CAPS test, and not some of the other tests on which Mr. Kolenovic scored extremely high and off the charts.
Provided all of these tests?
You know, that was actually something not completely developed at the evidentiary hearing, the extent to which he was provided everything. He certainly was provided the Mississippi Civilian Scale, PTSD, for which Mr. Kolenovic was multiple standard deviations above bad
And this doctor
Vietnam.
disagreed. This doctor, who's an expert in the field.
Disagreed, who also agreed that he never interviewed Mr. Kolenovic for a single minute. He acknowledged that if he had been hired, the first thing that he would have done would have been to sit down with Mr. Kolenovic and to have spent a lot of time speaking with him and interviewing him. He never contacted Dr. Pittman, on whom he bases his entire analysis. And he didn't there's no evidence that he contacted any of the other docs. So he was not in a position
So
to
your
make a
answer is
definitive.
if Dr. Johnson had been contacted, which is what Dr. Fox recommended, and had run the same test and concluded no PTSD here, or certainly not a very strong case, you would say there's certainly not a basis for a new trial because 15 years later, some other doctors say there is a different
Well,
conclusion.
that might be, but I also want to make it clear that Dr. Fox did not specifically say you must hire Dr. Johnson or even suggest, he never even
Gave
had
him his
the,
phone number and his
what he did was,
background.
let's be completely accurate about it. He gave his phone, he left a phone message with his associate, with trial counsel's associate,
Now
giving the
judge.
name of, excuse me, now a
Now
judge,
judge.
Judge Mastriani. He left a phone...
Co-counsel.
Co-counsel, but left a phone message with Judge Mastriani, basically giving Dr. Johnson's name and the name of a lawyer that had once used him as a possible follow-up for a person who was capable of doing it. But this court has never held... So when I come into the case along with Professor Dershowitz, we had a decision to make about what experts we were going to be using to do the follow-up testing that Dr. Fox recommended that Attorney Bongiorni didn't do. And as I indicated in one of my filings,
Picked a good group.
and it's in the record, sure, we picked people that we thought would be appropriate, but that also had the capacity to explain concisely and articulately to the court why the defendant was suffering from a severe case of PTSD. Obviously, kind of more practical things fit in. The experts that we picked were all local, as opposed to an out-of-state expert.
All the way down in New Haven, right?
Well, that's true, but these experts that I picked were in Boston. I think that's on the record. So
Is your client incarcerated? Never mind, that doesn't matter.
he's at MCI Norfolk and has been for a good long time. But in any event, I would submit this case really is far more egregious, the mistake that was made. And Attorney Bongiorni is a wonderful attorney. There's no question, a very skillful, very competent attorney who in many aspects of this case, he did a great
It's
job.
more egregious than Roberio?
I would say it's more egregious in the sense that in this case, Dr. Fox testified that he was extremely frustrated that after telling Attorney Bongiorni that Mr. Kolenovic was suffering from PTSD, that was his primary diagnosis, and that along with his history of alcohol dependency created this explosive cocktail of a dual diagnosis, which is even far worse. Their synergy is the word that he used. They were more than the sum of their parts. Attorney Bongiorni nonetheless never gave him a chance to explain the significance of this PTSD diagnosis. I would also beg to differ with Justice Cordy in terms of PTSD sort of being a fly-by-night, Johnny-come-lately to the psychiatric psychology scene. PTSD was in DSM-2 in the early 1980s, and it's been in DSM-3, and it was in DSM-4 at the time this case went to trial. So it was
This is
a
a jury
well-established...
going to be selected from the community. And if you go back 15 years or so, my sense is jurors would be a little skeptical where someone has had no prior mental health history. All of a sudden, I have PTSD. And therefore, I mean, there's a trial lawyer has to make these judgments. He's got to persuade people from the community.
But a trial lawyer has to make these judgments after, according to Strickland, and it's been adopted by this court in a number of cases, after having made reasonable investigations.
Well,
And
he
he's
did make an investigation.
But he
He
didn't.
got you tell me that Fox said this is determinative, PTSD.
Fox said this is a primary
and the lawyer
diagnosis.
said, I gotcha.
And if he said, if you want to understand this, you need to do follow-up investigations. When Bongiorni testified at the motion for new trial hearing, when I asked him, did he have any background in psychiatry, he said no. Have you read any of the learned treatises or articles about PTSD? He said, well, I've read some newspaper articles. That is not what I think this court has historically required of counsel under the first prong of Safarian.
He could have had Dr. Fox testify about the PTSD primary analysis, which Dr. Fox was so persuaded of. He could have had him testify to that.
He could have.
But then he would have had to expose your client to actually be examined by a Commonwealth
Well, but
psychiatrist.
he never even got it so far as even understanding whether PTSD would make a viable insanity defense, lack of criminal responsibility defense, or whether it otherwise could have assisted him in negating the mens rea required for malice, or could have been relevant under the Rosenthal-Rostkowski line of cases to extreme atrocity or cruelty. Those were issues that the jury never got exposed to. Instead, they were left with a misimpression of Mr. Kolenovic as just being a mean, vicious drunk who killed someone, rather than someone who, as a young child, was beaten mercilessly with electrical cords, belts, and 2x4s by his father on a daily basis from age 6 through age 14 or whatever it was.
Let me ask you about that, though. Are you because, as the judge found, at the time that Mr. Bongiorni was representing your client, those details, he was saying nothing about any of that, correct?
Bongiorni never didn't ask a lot of those questions, and he was not responding.
In fairness, there wasn't that kind of information available?
Well, what I think the evidence shows is that he was initially reluctant to cast any blame on his father, as many people who are victims of this kind of abuse are, and we've seen it in the newspapers recently with respect to domestic abuse, and that he was a reluctant reporter. But as soon as my expert certainly started interviewing him,
Been convicted at that point. I mean, it's just it's hard because even he is in a Monday morning position at that point.
I did ask Attorney Bongiorni whether he was ever directed by Mr. Kolenovic not to raise an insanity defense, not to bring up the issue of PTSD. And my recollection of the 2005 evidentiary hearing testimony was that he said no. That Mr. Kolenovic never instructed him. This was actually, and the reason was that Attorney Bongiorni really never explored these issues and never really sat down with Mr. Kolenovic and explored the issues with him. I think that's clear.
Let me ask you a question about this. Didn't the judge determine that Bongiorni took appropriate steps to investigate various defenses? So it's not really, I think the judge didn't rule that he failed to investigate. The judge ruled that, as I read her decision, that he made a tactical decision to offer solely the intoxication defense, and that was manifestly unreasonable. So it wasn't the failure to investigate fully, it was the decision to just go with the intoxication. So could you speak to that?
Yes, I think that's, Justice Lenk, I think that's absolutely correct. She found that it was a tactical decision, that it was manifestly unreasonable, that Attorney Bongiorni's decision in this case was uninformed, that she, quote unquote, he had a rudimentary understanding of what PTSD was.
So was it really that he failed to investigate, but she said it a different way? I'm getting a little confused here. You know, it was manifestly unreasonable because he had only a rudimentary understanding, and so he made the wrong tactical decision? And is that really not the equivalent of he failed to look into this enough?
That he didn't conduct the kind of reasonable investigations that make further investigation unnecessary. That's the language in Strickland that this court adopted in Commonwealth versus Dennis and numerous other cases. That's the language in Strickland.
No, I understand that. I'm asking the judges.
Essentially, that's my understanding, is that she found that he made a tactical decision, that it was a manifestly unreasonable decision not to conduct the further follow-up testing that Dr. Fox, who went out of his way to write this opinion against Attorney Bongiorni's advice because he was so frustrated with Bongiorni's attitude in this thing. Bongiorni was just so self-confident.
Manifestly unreasonable decision wasn't to put on the sole defense, but not to investigate further?
Not to conduct the investigation so that he could have informed himself to have made an intelligent decision whether to put it on or not.
So
and really, ultimately,
go ahead.
I was going to say, ultimately, you know, his decision was sort of premised on a kind of general, vague background, lack of faith in psychiatry and the belief that this is all just hoo-ha.
So if he had done a comprehensive investigation following up into PTSD and decided, perhaps persuaded by Dr. Johnson, that he didn't think that there was enough evidence of PTSD that it would persuade a jury, and therefore I'm going to rest on the intoxication defense, would that have been a Safarian violation?
I would say that would be a very, very different case, but the answer would be not necessarily. I think if the defense lawyer had prepped himself, had actually understood what PTSD was, had sat down with Dr. Fox and let him explain what the elements of PTSD were, which he didn't, certainly if he conducted the follow-up testing with Dr. Johnson or anyone who could have at least explained this to him, and then made a decision, presumably after speaking with the defendant, that would certainly have been an advisable thing to do.
But then how do you survive the second prong of Safarian if a competent attorney acting entirely appropriately pursuant to the standard of care may have reasonably decided not to pursue it? Because if he had decided not to pursue it, the case looks just like it did when it went to trial, and there wouldn't be any consequence to the failure to do so.
Well, if you're asking me why there was prejudice in this case,
Right.
there was prejudice in this case because there was evidence that there was this intense synergy between the PTSD and the alcoholism that created this dual diagnosis that created this explosive cocktail. Number two, even as Attorney Bongiorni recognized, now that he understands what this is all about, he would have put this on because it would have made Mr. Kolenovic far more sympathetic to the jury, and it would have had far greater explanatory power. Everyone was trying to figure out why someone would kill their friend in this manner based on what seems like a silly little insult.
So, but I hear you then saying that to show prejudice, you would have to show that he ultimately would have had to pursue this defense. It would not.
I do. First of all, I would say that the scenario you give me is a very, very different case.
I understand, but it sounds as if that could not be. If that's the case, there can't be prejudice because the defense would not have been offered. You need to show prejudice. You need to say that a competent attorney would have offered this defense.
You're saying the difference is that you're saying in your scenario, if Attorney Bongiorni had actually educated himself, had understood what PTSD was, had gone out and done the testing that Dr. Fox had advised him to do, and then said, let me think about this. Will this add appreciably to my defense here or not? Well, I guess Chief Justice Gantz, you're right. Probably it would have been a bad decision to have gone just with the alcohol, given the fact that it may be
Would have
that
been
we were
manifestly
writing.
unreasonable?
I think it might be under these particular circumstances. It might be manifestly unreasonable because it would have been clear if he had done the testing and had educated himself that the so-called two horses that he said he didn't want to ride could have been hitched up to the chariot and would have produced a 3-horsepower chariot rather than a 1-horsepower chariot.
Would you say in those circumstances, if he'd done the investigation and if he'd gone forward, I guess this is the question, if he had gone forward with the dual diagnosis defense,
Yep.
would lack of criminal responsibility have been a necessary component of that?
Well, it's quite possible that he could have decided not to raise a McCool
But I mean,
defense
is
could have just gone on a lack of.
But how have you argued it? Have you argued that it should have been a full lack of criminal responsibility? Is that your position?
In our motion for new trial and throughout the hearing, we've argued that this evidence would have been relevant to 3 separate things. It would have been relevant to the lack of mens rea. It would have been relevant under Ruskowski to the general approach to extreme atrocity or cruelty, and it also would have been the basis for a full-blown insanity defense. And the insanity defense was something that was, that was never presented to the jury. So certainly they were deprived of that other available substantial ground of defense.
One more question, if you would. So we're reviewing the allowance of a motion for a new trial based on ineffective assistance of counsel, based on a conclusion that counsel made a manifestly unreasonable tactical decision. What's the standard we use to determine whether the judge was correct or not correct, that this was a manifestly unreasonable tactical decision? abusive discretion on the judge's part, or what's the?
Well, yes. I mean, first of all, this court, of course, accords a trial judge sitting presiding over a motion for new trial super deference, because the trial judge has deep familiarity both with the trial itself and also with all the post-verdict, post-conviction facts that have been elicited, and this judge certainly did that. You know, I guess the second thing that I would say is that the court is supposed to be essentially in examining a judge's grant of a new trial motion. I think this court is looking for an error of law or an abuse of discretion.
But the question is whether manifestly unreasonable is some sort of, is a legal standard that we should say, well, she said manifestly unreasonable, we look at that de novo, or do we just say, well, it's just an abuse of discretion standard as to whether she got that right?
I think it's clear that Your Honors are supposed to accord the motion judge, and especially a trial judge, a measure of discretion in making that determination, because she really knows the facts of this case in a way that it's hard for an appellate court operating at this removed to do that. But in addition...
So you're saying that for you to lose, we would have to find that she abused her discretion in finding that it was manifestly unreasonable to not raise this defense?
I would say that I would agree with that. This court has recognized on numerous occasions that where there's a grant of a motion for new trial, a trial judge, a motion judge, can make that determination without being subject to having his or her opinion being, ruling being disturbed, even if the law or the Constitution of this Commonwealth or of the United States doesn't require it. The judge has broad discretion here, and she's ultimately making the determination whether or not under Rule 30B justice was done. And she took that very seriously. She gave the Commonwealth every chance, and she ultimately determined that justice was not done in this case, knowing full well that this was a very unpleasant, difficult killing. But she also knew the circumstances, and somehow she recognized alcohol alone didn't cut it. The jury needed to be provided the information about the defendant's history and his mental disease or defect.
The jury didn't hear anything? I'm sorry, no, I know you're over time. The jury didn't hear any evidence about his personal history of having been beaten by his father and or any of that that would have made him sympathetic? They didn't hear anything like that?
No.
Thank you.
Thank you.